Well,
Well,
go ahead.
this is an unusual case in my experience, Your Honor. So, Ms. Weatherspoon, we obtained two sources of rental assistance for her, and her balance was paid in full, but she still owed September rent, and she talked to the office about doing a payment plan and had terms of a payment plan that we thought we were all in agreement with. And today, while I was how while Miss Inget and I were trying to get the terms of the COD in writing so that we could submit it to the court, it I was told that Miss Weatherspoon had moved out and surrendered her keys on September 19th. So I talked to Miss Weatherspoon about this, and my understanding of what happened is Miss Weatherspoon's partner was murdered in July. The people that are being investigated for killing him some of them live in Hamilton Crossing, or associates of them live in Hamilton Crossing. They've been harassing her. She's felt very unsafe. She has young children. So she went to the office to ask to be moved, and she was presented with a VAWA form to fill out, which she submitted along with a police report about the harassment. And she agreed to surrender her keys on the 19th. Now, she didn't know that this meant she was giving up her rights to her housing. She thought this was a process that she had to comply with to be moved to a new place. And so she was I mean, she did turn in her keys and she did sign that paperwork, but she did not understand the repercussions of doing so. And unfortunately, I didn't find out about this until today. I think she viewed it as separate from the non-payment of rent case and thought that she had handled it properly herself. So as we sit here today, she did present a payment plan. She owes September rent. She had a acceptable payment plan to catch that up by mid-October, as well as pay October rent by the end of the month. But now she's possibly homeless with small children who are, still lost their father this summer, and is just kind of tragedy and trauma on the family if that's the result of this process.
Mr. Fink. She turned.
This is the kind of courtroom moment that looks calm but hides a storm. Two worlds collide here, human tragedy and cold legal process, and in the next 2 minutes you'll see how a single misunderstanding can decide a family's fate from the very first line. The defense lays out a heartbreaking backstory. Ms. Weatherspoon's partner was murdered, her family has been harassed, and she feared for her children. You can feel the courtroom tilt from routine procedure to human crisis. The defense explains that she accepted housing help and thought she was following the rehousing process. She filled a form, handed in keys, and believed she would be moved to safety. That belief, genuine, confused, desperate, is the emotional engine of this opening. The tone is sympathetic, the language is plain, yet every sentence raises a question. Did she know what surrendering the keys truly meant? The audience is left leaning in empathy on one side, a looming legal technicality on the other. Mini hook into the next segment. The simple detail of keys in a Dropbox is about to become the exact hinge the lawyer sees.
Turned in a notice to vacate saying she'd be out on the 19th. She put her keys in the Dropbox. The landlord, with a notice to vacate and the keys, took possession of the unit. It was essentially vacant. I'm not saying it was empty, but from our perspective, possession has been surrendered. The landlord has taken possession, and I there's with and reasonably took possession, and it's not an unlawful ejection. And she did also turn in a form under the not under VAWA, but under the statute, asking to be removed, I think, under the state statute. But we have possession of the unit because she surrendered possession.
I don't know, Ms. Bauer, that I can order them to put her back in under these circumstances. I mean, it is kind of strange, but she voluntarily gave up the unit over in that direction.
Well, Your Honor, I don't know if you want to speak to her directly, but she thought that she was complying with the process that was necessary to have her rehoused. She did not understand that she was completely giving up. And I would say that my conversations with her did not align with her believing that she was giving up because she was talking to me about how she was going to catch up her September rent this whole time. So and also it doesn't really meet the VAWA, the conditions of VAWA, but she was given this form by the office to fill out. So I think it was a very confusing situation for her, and there should be some consideration for her confusion.
Well, yes, certainly. I mean, I would.
Now the courtroom shifts. The landlord's counsel steps forward and speaks with the precision of someone closing a case. Keys were handed in, notice to vacate was given, possession was taken. The language tightens, possession has been surrendered, and the mood goes from sympathetic to procedural. This is the first real confrontation, two different interpretations of the same event. On one side, a frightened tenant who believed she was being rehoused, on the other, a landlord asserting a clear, legal closure. You can see the judge physically weighing definitions and documentary evidence, in particular, photos of an apparently empty living room. The audience is forced from emotion into a legal puzzle. When does human confusion end and legal fact begin? The tension rises because the stakes are practical and immediate. A mother and small children could be.
Have, in looking at it, if she had, say, turned in the keys, but they had not yet taken possession, that might be one thing. Or, landlord had a judgment, they were issued a writ. That's one thing. I'm not sure that on a possession case, where I've not rendered judgment, but then the tenant has voluntarily surrendered, I don't know how I put her back in. If you're following what I'm saying. I mean, I get it if the landlord had done something during the course of that process, this process, that would lead her to leave or to surrender, but that's not what has transpired here, what I understand. I mean, the only thing that's leading her to do that is rightfully or wrongfully, but it's not the landlord that's causing the angst.
Your Honor,
people.
if I could just say one more thing, Your Honor, I don't think she would have turned in the keys on the 19th if she hadn't believed that that was what she needed to do to be rehoused. And I think that information did come from the landlord. And she's nodding her head yes.
Your
That
Honor,
there,
may I think there's no reason not to believe Ms. Bauer when she says her client made a mistake, but yet she surrendered possession. And by the way, Your Honor, I've got some photographs. I'm looking at an empty living room. She surrendered possession. She's vacated the unit. I'd like to submit
This is the heart of the case, the judge thinking out loud. Listen closely, he carefully parses timing, intent, and precedent. He considers scenarios where keys were handed in but not yet accepted, or where the landlord had already secured a judgment. The defense pleads that the tenant acted from confusion, not intent, that she never wanted to abandon her home. The landlord repeats the plain fact of possession. The judge's voice is the audience's compass here, it moves between empathy and legal constraint. This section is suspenseful because it's cerebral, the drama is the judge's internal balancing act, and his questions expose the thin seam between fairness and the rule of law. Viewers feel the weight of the decision because the judge's logic will determine whether compassion can override a technical surrender. Mini hook into the next segment. The verdict is coming, and it will reveal whether the law bends or stands firm.
order of dismissal that includes the line that defendant surrendered possession it may be there's some relief for her somewhere in reapplying for a unit or seeking some assistance in finding another unit, but she moved out. My client has possession. I think this case is moot.
Yeah.
Your Honor, if I could just say one more thing. Miss
Sure.
Miss Weatherspoon was homeless when she moved into the unit, so she never had for a lot of furnishings, and she didn't remove the belongings that she had from the unit because she didn't realize that when she turned in the keys that she was essentially surrendering the unit.
Your
I
Honor,
don't know how that's.
I don't want
the
to
case.
prove the case, but these pictures don't back that up. And I'm not saying anything about Ms. Bauer, and I think she is reporting what she believes to be true, but the photographs don't support that. And I also think it doesn't matter. She surrendered possession. We
Yeah,
all
I
agree.
mean, I don't know that there's anything I can do. The issue of possession by her actions has become, and I think that's probably true, that it's now moot. I don't, in this case. I mean,
Okay.
she did the act.
I'll submit an order.
All right. So what I'm going to do is I'm going to dismiss this case. The issue is moot. The provision will read that defendant did surrender possession of the property.
Thank you, Your Honor.
All right.
Thank you for listening to us, Your Honor.
All right. Thank you.
The ending lands with a sober, almost inevitable resolve. After weighing testimony and photos, the judge concludes the case is moot, the defendant surrendered possession. The legal machinery closes, the motion is dismissed, and the record will note that possession was given up. There's no theatrical gavel bang, the finality is quieter and heavier. The defense thanks the court, the room exhales. For the viewer, the emotion here is complex, sympathy remains, but the legal reality is plain. The clip finishes on a bittersweet, contemplative note. The law has spoken, but the human cost lingers. It's a powerful conclusion for your video because it leaves viewers asking bigger questions about process, vulnerability, and whether systems protect those they intend to help. A final note to pair with footage. Finish the segment with a slow cut to the empty courtroom or the judge's closing line. It sustains the emotional aftertaste and prompts viewers to reflect.